Hello, everybody, and welcome to History/Law Bite number 277, dated June 16th, 2021. I'm Walter, your mobile historian and blue-collar scholar. This History/Law Bite is entitled New York Times Co. versus Sullivan, 376 U.S. 254, 1964. Thanks for tuning in. You've probably heard of this Supreme Court decision in passing, or maybe, in your social studies or civics class, or maybe even one of your college courses when you were discussing the First Amendment, okay? But if you've never heard of New York Times versus Sullivan, this was a landmark U.S. Supreme Court decision, a First Amendment case that substantially increased the freedom of the press and equally inhibited the ability of prominent public individuals to sue the press, media outlets in general, for libel, okay? So, with that in mind, we begin, all right, the same way the U.S. Supreme Court begins. All rise. The Chief Justice and the Associate Justices of the Supreme Court of the United States. Oyez, oyez, oyez. All persons having business before the Honorable, the Supreme Court of the United States, are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Please be seated. Mr. Chief Justice, and may it please the court, we now begin with with New York Times versus Sullivan, okay? New York Times versus Sullivan was a case that was decided in the very tense and hostile days of the civil rights movement in the United States, okay? And that is the context of this case, all right? That's what's going on in the background. That is what created this case, all right? An advertisement in the New York Times, a very prominent newspaper that I know you've heard of if you've never read it, okay? And the accuracy of information printed therein, all right? So let's dive into the facts. So this case began in 1960 when the New York Times ran a prominent advertisement that was entitled Heed Their Rising Voices, okay? That was paid for by the Committee to Defend Martin Luther King Jr. and the Struggle for Freedom in the South. All right? Like I said, the civil rights movement is essentially the context for this case. All right? So within the body of the advertisement, the committee solicited donations to defend Dr. King against a perjury charge in the state of Alabama. All right? They described certain actions against civil rights protesters. And not all of these depictions were entirely accurate, okay? And some of the allegations were against the Montgomery, Alabama Police Department. So, the Montgomery Public Safety Commissioner, aka Police Chief L.B. Sullivan, who is our respondent in this case, took major offense at these allegations, all right? In spite of the fact that none of them were directed towards him personally, but instead his officers, okay? So, but nonetheless, he contended that, the inaccurate criticism of actions by his officers was defamatory to him because he was the police chief. So you come at my officers, you're coming at me, was his logic, okay? So Alabama law required, before one could file, libel suit, that you write a letter to the entity that printed the information and demand a public retraction. And if they refused or simply took no action on your request, then you could file the libel suit against them in the state of Alabama. All right. So Mr. Sullivan sent such a request, but instead of retracting the information, the New York Times responded to his letter with questions of their own. They said, Mr. Sullivan, I'm sorry you've taken these statements personally, but we weren't talking about you, dude. We were talking about the police officers in Montgomery. All right. So if you wouldn't mind, would you please tell us exactly, what in the article is offending you? All right. So Mr. Sullivan was obviously quite angry at that. And instead of replying to the Times inquiry, he instead, having done what was required of him, filed suit in the Alabama courts against the New York Times for, a defamation suit for libel. All right. And, he also sued 4 black ministers that were mentioned in the article itself. So with that in mind, he was able to prevail and secured a $500,000 judgment in the local circuit court in Alabama. Now, for context, that's roughly about $4.5 million in today's money. All right, so that's not a small judgment, okay? And the decision, an award by the circuit court was affirmed, in the Supreme Court of Alabama. The Supreme Court of Alabama held that the First Amendment did not in any way protect libelous publications. This is what prompted the New York Times to seek review in the Supreme Court of the United States. Okay? So, this case was argued on January 6th, 1964. All right? And the issue presented to the justices was this: did Alabama's libel statute violate the First Amendment's protections of free press and free speech? Okay? The decision was handed down on March 9th, 1964, where a unanimous Supreme Court ruled in favor of the New York Times. In an opinion by Justice William J. Brennan Jr., all right, the Supreme Court held, quite simply, that states cannot, under the First and 14th Amendments, award damages to public officials for defamatory falsehood relating to his official conduct unless he proves actual malice. Okay? Actual malice is the standard that was established in this case to sue for libel. All right? And actual malice is defined as follows. First, that the statement was made with knowledge of its falsity. Translated, you knew damn well it was false when you printed it. Or with reckless disregard of whether it was true or false. Thus, you didn't give a darn one way or another whether or not the information was true or false. You didn't do any due diligence to find it out. You just printed it anyway, come what may. All right? So it had to, one of these elements had to be satisfied in order to prove actual malice according to the court's decision. Okay? Next, Brennan held that application of state courts by a rule of law, whether statutory or not, to award a judgment in a civil action is state action under the 14th Amendment. Next, expression does not lose constitutional protection to which it would otherwise be entitled because it appears in the form of a paid advertisement. Next, factual error, content defamatory of official reputation, or both, are insufficient to warrant an award of damages for false statements unless, okay, actual malice, which is knowledge that the statements are false, or in reckless disregard of the truth, quite simply, is alleged and proved, okay? So the court in this case, as was a huge break from existing libel law, the court shifted the burden of proof in libel suits from the defendant to prove the truth of the statements over to the plaintiff, all right, to prove that actual malice, all right, was in play here. And remember, that's either full knowledge that the statements were false or that the defendant had shown a total reckless disregard for the truth. Okay? Next, state court judgment entered upon a general verdict, which does not differentiate between punitive damages, as to which under state law, actual malice must be proved, and general damages, as to which it is presumed, precludes any determination as to the basis of the verdict, and requires reversal. Okay? Where presumption of malice is inconsistent with federal constitutional requirements. Next, the evidence was constitutionally insufficient to support the judgment for respondent, since it failed to support a finding that the statements were made with actual malice or that they related to respondent. Remember, these statements were not against our respondent, Mr. Sullivan. They were against his police officers. All right? So that was a huge weakness in his case from the beginning. Okay? So accordingly, the Supreme Court reversed the Supreme Court of Alabama and remanded this case back to the state courts. All right? Now, not everyone completely agreed with Justice Brennan's logic here. There were no dissents, however, but Justices Hugo Black and Arthur Goldberg both filed concurring opinions because they felt that Justice Brennan's opinion did not go far enough. Indeed, both Justices Black and Goldberg argued that the First Amendment should have been interpreted much more broadly here, okay, to essentially protect an unconditional freedom to criticize official conduct, okay? They felt that the actual malice standard was, too much of a limitation on the First Amendment's guarantees of free speech and free press, all right? And, they make very good points in their concurrences. Let's keep in mind that Justices Black, Goldberg, and Douglas were all First Amendment absolutists who would tolerate little, if any, primarily any, restrictions on the First Amendment. So, the legacy of this case is quite clear, all right? The New York Times versus Sullivan decision fundamentally altered the nation's libel laws in virtually every single state in the Union and gave far greater protection to defendants accused of libeling public officials. The decision expanded press freedom to levels never before seen and made media outlets sleep a little better that night. All right? So, like I said earlier, the Times case shifted the burden of proof from defendants, okay, over to plaintiffs to prove the actual standards required to prevail in a libel suit, all right? So, of course, we know that the plaintiff had to prove actual malice, okay? Thus, the plaintiff had to prove that the defendant had, knowingly printed information that was false, okay? They knew it was false when they printed it. They knew it, all right? Or that they had printed information that was had shown a total reckless disregard for whether or not it was truthful. In other words, they didn't do any research to find out whether or not it was true. They just printed it anyway. Come with me, all right? So, many constitutional law scholars have argued that New York Times Co. versus Sullivan was, one of the most far-reaching and most protective decisions in history with respect to freedom of the press. And I am inclined to agree with them, okay? This was a groundbreaker case and certainly proved useful in the years ahead, with continuing coverage of the civil rights movement in the South, as well as, the later, issues surrounding the Vietnam War and the government secrecy with respect to that conflict. Okay? Now, a couple of interesting facts about New York Times versus Sullivan was that Justice William J. Brennan Jr., who was the author of the majority opinion, one of my heroes, by the way, and an outspoken liberal who broadly interpreted the Bill of Rights, hated the press. Justice Brennan could not stand the press. He felt they were very intrusive, in the way they ignored people's privacy and outright invaded it, quite often. And, he couldn't stand them, just to simplify it. And, in spite of that, his strong beliefs in the Constitution's protections led him to write a landmark opinion substantially increasing the press's freedom. That, ladies and gentlemen, is a judge right there. All right? And, another interesting thing about this case was that, this was a very politically watched case. Okay? Politicians and other officials were all eyes on New York Times Co. versus Sullivan and waiting and anticipating, sweating bullets to see how the Supreme Court would rule, not to mention media outlets, okay? So, in the audience, the day the case was argued, January 6, 1964, among others, was none other than the legendary Dr. Martin Luther King Jr., who had come to watch the spectacle, all right? And Justice Arthur Goldberg, who owned a copy of Dr. King's book, Stride Toward Freedom, saw King in the audience and slipped his copy of that book to Dr. King so that Dr. King could sign it. The justice wanted an autograph. He was very tremendous admirer of Dr. King and, unwavering supporter of the civil rights movement. Justice Goldberg was a man who left the court too soon, So just wanted to point that out. You may find that interesting that, yes, even Supreme Court justices like autographs, okay? So that, ladies and gentlemen, is New York Times Co. versus Sullivan, a decision that substantially increased freedom of the press and substantially inhibited the ability of public prominent officials to sue media outlets for libel, okay? So once again, the holding of the Supreme Court in this case was that the First Amendment requires that to successfully sue, all right, for libel, all right, the First Amendment requires that the plaintiff show actual malice on the part of the defendant. And that is defined either as the defendant printed information that they knew was false. They knew it was false when they printed it, or information that they printed with total and reckless disregard for the truth. In other words, they didn't do any research or any other type of homework to find out whether the information was true. They just printed it anyway, all right? Didn't care, all right, whether or not it was accurate, all right? That is on the plaintiff to prove. And that represented a break from existing libel law as it was known at the time. All right, so that's the holding. New York Times Co. versus Sullivan, 376 U.S. 254, 1964. It established the actual malice standard for libel suits. Okay, so if you have any questions or controversies, leave them down below and I'll be happy to answer them. If you learned a thing or two or gained some insight from this case, drop me a like. It means a lot in the YouTube world. And if you have not subscribed to my channel, please do so now. It would greatly be appreciated. And you won't regret it because you'll get more good videos like this. So take care, stay safe out there, and I'll talk to you at the next bite. Peace.